Good afternoon and welcome to my presentation on FERPA, the Family Educational Rights and Privacy Act. This presentation was created for USD 297 and EDL 850 school law class through Dr. Moody and Fort Hays State University. When you look at these children, we should see in each and every one of them someone's treasure. Most of us have children of our own, and we would hate it if anybody in a position of leadership or trust shared information with somebody else that could be used to damage or harm the self-esteem of these little treasures. Therefore, it is incumbent upon each of us who works in a school system to know the laws that are set forth by FERPA. It will allow us to help protect these children and allow us to protect ourselves from legal liability when sharing information about students is necessary. What is FERPA and what does it do? Well, FERPA is an acronym for the Family Educational Rights and Privacy Act, as I mentioned earlier. Since it is a federal statute, any entity that receives federal funds is bound to the laws that are set forth in FERPA. It was enacted in 1974 and covers more than just public schools. It also affects hospitals, universities, and other entities, of course, that receive public funds. Basically, FERPA provides a legal framework for sharing personally identifiable information regarding students under the age of 18. It binds educators and administrators to some very common sense rules about how we discuss student information. As we will find out as we go through the FERPA presentation, these common sense rules are just that. They're common sense. They are things that all educators should know and do instinctively. The first thing that we have to know about FERPA is that it is serious business, and school personnel must know their boundaries. We all know people who have had issues regarding student confidentiality, and they are not pleasant issues to have. Parents are, of course, and understandably, very touchy about how their children are handled in public schools and how the information about those children is disseminated to others. We have to know the rules of FERPA. What does FERPA allow schools to do then, without the consent of a parent? Obviously, we handle all kinds of information each and every day about students that has to be disseminated to one party or another. FERPA allows allows teachers to disseminate directory information about students. That would include the student's name, address, telephone number, date of birth, place of birth, honors, awards, and dates of attendance. Also included in this list of items is participation in a sport and the height and weight of a player. Now there are qualifications to that list. Schools must notify yearly parents that such information will be published, and a parent can request that such information not be published. That has happened before. FERPA also allows school personnel to share educational records under certain conditions and under very strict guidelines that must be observed. Schools may share information with school officials that have a legitimate educational interest to know that material, other schools to which the student is transferring, specific officials for audit or evaluation purposes, officials concerned with student financial aid, researching organizations under certain circumstances, accrediting organizations, court officials and others in regard to a subpoena, health and safety emergency officials, and state and local authorities within a juvenile justice system. Once again, there are strict qualifications that apply to all of these things, and school personnel must know what those qualifications are. Once again, if in doubt, ask. If in doubt, ask is a very important guideline that every school personnel needs to keep in mind as they deal with FERPA issues and all issues regarding student records and information. A classroom teacher can't be expected to know every aspect of the minute details of FERPA. So, if asked to disseminate information that does not fall into the list of information that can be disseminated without consent, the teacher needs to ask a school representative or administrator to find out exactly what the laws are before any action is taken. Staff, parents, and students all have rights under FERPA. Parents or legal guardians may inspect their child's school record. Both academic and discipline records are included in that. They may challenge the accuracy of the record. And of course, there is a legal framework that exists for how the challenge process works. School personnel must be aware of that legal framework. Parents and legal guardians must be notified in writing before the school complies with request for educational records. And non-custodial parents have court-honored rights to the child's records. Students also have rights under FERPA. Students under the 18 see parents. They will know your rights. They are the recipients of the protections discussed throughout this presentation. Eligible students are students that are 18 years or older or are enrolled in post-secondary education in a post-secondary institution. They have the same rights as parents. They may inspect and challenge a school record, and they may determine who may view files. School personnel also have rights under FERPA. School personnel may view student records if there exists a legitimate right to do so. That would include generally teachers, counselors, and administrators. School personnel must leave a record of having viewed those student files, including on that record what files were viewed and when they were viewed. School personnel may also maintain records of student disciplinary action. They may share these records with school officials who also have a legitimate need to know about this student behavior. In most cases, this student behavior is behavior that is risky to other students that they may interact with. There are risks involved in violating FERPA, and unfortunately we all know too many stories of teachers who have been careless when handling information about students. First of all, interpersonal relationships with parents and students could be harmed. In reality, that's one of the most devastating impacts of violating the statutes of FERPA. The students may be harmed by the information that you share about them, and occasionally that information will be used against them in bullying incidents or in other harmful activities. There are also legal risks involved with violating FERPA that teachers and other school personnel need to know about. A defamation lawsuit with regard to slander would be one such legal risk that teachers run when violating FERPA. Slander is oral defamation when a teacher or when that information is used to harm the reputation of a student. Other risks involved that are legal in nature include a libel defamation lawsuit. A libel defamation case comes about when material is written about a student using confidential material that is used to damage the student and his or her reputation. So, what is the bottom line on FERPA? This law protects the rights of students, parents, and school personnel by providing a legal framework for appropriately handling student records. As such, we need to respect and understand FERPA. It is there to protect all parties involved. Also, by violating the law, staff not only subject themselves to legal liability, but also destroy the trust between the external public and the school. Violation of these fundamental student and parent rights is terrible advertising for a public school. And once again, if in doubt, ask. Don't act until you know the legality of your situation.